Well, first and foremost, thank you so much for Data Sanity to be here. It's an absolute pleasure to be here. And also, you guys have taken some time off your summer evening, so really appreciate that. It never gets bored talking about this topic, and it's very rare to have someone say compliance and regulation is a hot topic, so hopefully you guys find this interesting. So, why are we here and what is the topic? The EU AI Act. Just a heads up, it is a bit of a tongue twister, so I may use the term AI Act just for simplicity. So we want to cover some of the key concepts and principles that are affecting businesses, private sector, public sector in the coming months. And we are just on the back of one of the first major milestones, the 2nd of August 2025, so a couple of days ago, where the majority of the provisions on to Chapter 5, so for general purpose AI models, are now applicable. So you'll probably see a lot of news coming out in the next coming weeks. It all stems back to what is AI? What is the definition of AI? Now the running joke I usually say is everyone in this room and every AI conference you probably go to has a different definition of AI. So at least we can all agree to disagree in that respect. But it's important to distinguish between the two key definitions, the legal definition and the academic. The academic definition is traditional AI. So AI as we know it, so LLMs, models, machine learning, etc. Whereas the legal definition, and this is key, is everything that is automated decision making based on data. So by virtue of that, it brings into scope everything that is a prompt, an LLM, a model, or an algorithm. By way of example, and show of hands, who here uses Microsoft Word? Okay, keep your hand raised. So for those of you who raise your hands, lower your hand if you're aware that there are 22 models in Microsoft Word. Interesting, okay. If you go into Teams, so next time you log in, there is a feature called Connected Experiences. What this means is that they have now, so the 22 models in Word, every letter you type in Word, that data is being hosted in Azure. They are training their data, their models on your data, under some terms and conditions, of course. And if you go, there's a list, if you type in Connected Experiences now when you go home, there's a list of all the AI systems by legal definition that are being trained on your data because they've realized, yeah, they've scraped the entirety of the internet. Cool, they've got all their data. Whereas the most valuable data for them now, it's the live data. It's your ongoing conversations, your thoughts, the conversations there. That is why it's there. And yeah, unfortunately, this feature is automatically enabled. So what we did is we disabled it. And it's done at a tenant level. So if you do it at organization or enterprise level, it's disabled. And the CEO of the AI Founders actually advised the senior leadership team of a major reinsurer of this, and they disabled it across their entire global enterprise. So hopefully that gives you a bit of context. Now, cool. So what is the EU AI Act? And you'll hear different interpretations from different people. The way we like to think of it, it's a risk-based approach to regulation. There are different aspects of it, so there's product safety, and you have the harmonized standards aspects. Principally, it's risk-based. So the risk level of your AI system determines its compliance obligations. The same way that you have financial crime regulation, which is risk-based. So the risk of money laundering that you pose to a bank determines the risk level they assign to you. The process is called KYC. Show of hands, who's familiar with this term? Almost everyone, cool. So here we call the term KYAI, Know Your AI System. They compartmentalize or split the risk levels of an AI system into 4 levels, starting from the top. Unacceptable, so this one here. High, limited, and minimal or no risk. So this risk in this context is the risk of harm to an individual, so not company level, risk of harm to an individual's health, safety, and fundamental rights. So it's very much enshrined in consumer protection regulation. So it's backed up by the European Charter of Fundamental Rights, the Treaty of the European Union, and the Treaty of the Functioning of the European Union. So very much, but it's applied at a company level. So they have to look at how an AI system applies to an individual. By way of example, I'll come on to that in a minute. So it's unacceptable risk at the top. So these are ones that pose an unacceptable risk to an individual's health, safety, and fundamental rights. So for example, if they're using AI to do social scoring, so if you're applying for social benefits, you cannot do that. You just cannot. And the fines for that actually started February this year. And if you contravene that, it's 35 million euros or 7% of global annual turnover per AI system, per model, per algorithm. Harm, just a side topic there, covers emotional, physical, psychological, or otherwise. So those among you who have good lawyers, they will probably have a field day with that. The next one is high risk. So these are ones that pose a higher risk to an individual's health, safety, fundamental rights. There are a list of ones which are typically covered. So you have recruitment, HR, border control, asylum seeking, etc. Stuff like that is likely to be high risk. A lot of the companies we speak to are developing health tech products, or for example, if you're using it to screen CVs, that is likely high risk. And I would strongly urge you to get a list of all the models you have, create an inventory, and get them risk classified as step one. So next one is limited risk. So these are ones that, for example, chatbots or deepfakes, and these are ones that are permitted but subject to transparency obligations. By show of hands again, who uses Amazon here? And do you have a little chatbot that you interact with on Amazon if you want to make a purchase or get more information on a product? If you did, okay, a bad example perhaps. If you did use a chatbot in that sense, that would be limited risk, and it would have to disclose to you that you're interacting with a chatbot, or even on a banking app, if they're using AI-powered chatbots, they would have to disclose to you that any content generated for that was from an AI and what data has been used to train that. I don't know about you, but sometimes those generic customer services bots can be fairly irritating because of a lack of or vague information. So do feel free to, next time if you get that, ask it what risk level it is, and it would be interesting to see what response you get. The last one is minimal or no risk. So we mentioned here codes of conduct. The EU recently released the final version of the General Purpose AI Code of Practice, which essentially enforces voluntary conditions for providers of general purpose AI models. So people like Anthropic with Claude, Anthropic would have to comply with the voluntary obligations, indeed if they have signed the code. If I'm not mistaken, they are one of the signatories, and I believe OpenAI has pledged they have. I don't believe Meta have signed it, correct me if I'm wrong. That may change, but I think they were one of the ones that have not agreed to sign it. Now, where the EU AI Act is going to hit most, so if we think back to the pyramid here, is this one here, this orange one, which is high risk. The reason is these are the ones where they are trying to prevent the maximum pain being inflicted by AI systems. And when the EU Act was launched, the European Commission estimated between 20 to 30 of all AI systems would be high risk. So it's not a sign of relief for businesses to go, phew, we're out the woods on this one, 70%, great. No, that's just an estimation. And what this means is any AI system, so model, system, algorithm, prompt, that is high risk, you would have to put in place all these requirements for each of them. I'll take you through a couple of examples. Conformity assessments. This is looking at an AI system and getting an assessment done of that system against a harmonized standard, like an ISO. Again, are you guys familiar with ISO? Okay, cool. Oliver is great. There's a standard called ISO 42001, which sets out the conditions for an ISO risk management system. So if you have, what this means is if a system is high risk, you would then have to get a third party to do an audit of that system against the standard, and they will then tell you if it's compliant or not. From an industry standpoint, I can tell you that businesses are not very happy about this. Nonetheless, it is a regulatory requirement. So once you do a conformity assessment, that will then tell you if it's compliant or not. The next another obligation is registration. So the EU is now setting up an electronic database of high-risk systems. So any member of the public, anyone in this room, anyone out there can go online and you can check, okay, cool, this system is high risk, and you can clearly see it in that public database. So as part of a firm's digital strategy, they all then have to articulate that it is high risk and where it can be accessed. Another one, and this is crucial, is this one here. And we foresee a lot of companies having issues with this. The reason is Article 72 requires any system that is high risk to be monitored on an ongoing basis for things like model drift, performance issues, bias, etc. And if any incidents are picked up, report them and manage them. And this is all formed under what they call a quality management system. So a quality management system are the processes you put in place to ensure that maximum quality is enforced for an AI system. Am I going too quick for you guys? Are you all good? Okay. Another one we have is human oversight, this one here. Article 14. What this means is that any high-risk system, anyone who oversees it has to have the necessary experience, knowledge, and expertise. In practical terms, you can't just repurpose someone from, let's say, HR to go, okay, do you know what AI means? Yeah, okay, now you're the chief AI officer. Cannot do that. In a financial services context, any risk manager would have to attest to regulator on a yearly basis what skills and qualifications they have to do this. And a similar practice applies in this context. Now, where we are today is interesting. So where we are, the EU AI Act entered into force on the 1st of August 2024. What that did is it started the clock. So from that day, the 2-year transition period was kick-started. What that means is there was 2 years for firms to get all their systems, all their controls, all their policies, and all their procedures in place. The common misconception we have is, okay, cool, we have 2 years. Whew, we don't have to do anything. Let's put our feet up and have a cup of tea. No. It's 2 years to identify all of your systems, get them all risk categorized, get them all assessed. And if any of them are high risk, if any of them are unacceptable risk, you've got to get rid of them or you've got to de-risk them. If any of them are high risk, put all the systems requirements referred to there in place, and then manage the other ones accordingly. So we've just passed the milestone I mentioned on the 2nd of August 2025. So we have less than a year now for firms to get all their systems identified. To draw on a practical example, we had a call with a major reinsurer yesterday, and they actually refer to this as an organizational change. So you're not just talking about a technology, you're talking about an institutional change at a company level. The way in which AI is viewed, processed, orchestrated, and implemented in organization is now being considered. And again, this is one of this insurance firm we spoke to, 40 years in the market, and they insure over $2.6 billion worth of assets. So they are not just thinking of this as another esoteric regulation. It is one which has practical implication. And the main things for firms is to classify the AI systems into the 4 risk levels, to do gap assessment, so identify where in the organization you have gaps, where are the AI systems most likely to be based, implement controls. So this is controls both at an AI system level, so what risk mitigation levels you have, so whether you, who's familiar with one or more of these terms? Human uplift, red teaming. Oliver, you again. So red teaming is where you essentially stress test the AI system to intentionally identify its faults and vulnerabilities to make sure it's safe before it goes to market. You're intentionally going, where are my bad points? And I need to find them before the bad guys do. So stuff like this. And that's controls at the AI system level. At the organization level, it's things like AI literacy. So making sure that you have an enterprise-wide strategy, that everyone knows what's going on, who has access to it, and everyone knows the difference between the legal and academic definitions of AI, etc. From some of you I spoke to before, students, that's great. because it means that the companies that are looking to employ their future workforce, anyone who knows what AI is, anyone who is familiar with them, your opportunities are going to be phenomenal, absolutely phenomenal. And in fact, this is probably at the start of one of the greatest periods in human history, because what the regulation is saying is you're implementing controls. And if AI literacy is a control, happy days, that's amazing. The next one is testing and validation. So you're testing your systems, setting up testing suites. So you're having metrics to measure for performance drift, bias. You can create this one is interesting because you can actually create your own metrics, or you can use the ones from ISO, or there's an institution I recommend looking up called the Future of Life Institute. And they look at various AI safety benchmarks, and they look at stuff from Stanford, MIT, and if you conduct tests against those frameworks, it's a good place to start. And the documentation in CE mark. So before any high-risk AI system is deployed, you have to stamp it that it has passed its conformity assessment. If it hasn't, then it's very likely to be removed from the market, or the company suffers reputational damage. We are now, because of this institutionalization phase, we are now seeing the regulators and the enforcement bodies taking it seriously. So what I mean by that is the ISO 42001 standard came out in 2023. And what happened is a lot of companies came out there and said, okay, we'll do your standard, we'll do your audit. And even the assurance market turned into the Wild West. So what came out recently is ISO 42005, which requires any auditor or any third party doing these assessments to be compliant. The regulatory controls and mechanisms being put in place are designed to, with one goal in mind, and that's to protect you. To protect your family, your friends, and from interacting with AI, understanding that it is now ubiquitous. Sorry if I've spent too long on that. The next one is guidelines for general purpose AI model providers. These recently came out for the European Commission, and they give the market a bit of flavor around what model is a general purpose AI model, the life cycle, the ones with systemic risk, and when an actor is a provider. So companies do not want to be a provider because the majority of provisions apply in this context. When is a model general purpose AI? Because not every generative AI model will fit this definition. The technical definition, for those of you interested, is if the flops figure, so floating point operations, is 10 to the power of 23 flops, which is a measure of computational power used to train an AI model. If it's systemic risk, it's 10 to the power of 25. So there's a technical difference between 10 to the power of 23 versus 10 to the power of 25. They do want to make sure that it doesn't stifle innovation. So there is some favoritism given to the open source community. What that means is if you have there are certain exemptions for open source AI models. Give that a update. So there are certain exemptions from the high risk obligations, as well as others if it's open source. But they're very specific on these because they're trying to prevent companies circumventing these or finding any loopholes. And I think Abhishek from earlier, you were talking about loopholes earlier. So it applies, for example, it must be free and on available license, and not all open models qualify, and it has to be legal review for all monetization models at a company level. Interestingly, I was just reading on the way here, Sam Altman, I believe, has now released a couple of open source or a new open source AI model to compete with or to prevent a lot of users moving to DeepSeek. So the open source, there's obviously a lot of way to go in the open source movement, but I must make the caveat that it has to be openly available, and I strongly recommend getting legal advice to any company that does consider this, of course. So, AI system discovery, why it's important. Am I good for time, Yara? Oh, okay. What we see is 90% of systems are unknown. So what we mean by that is, if you have 100 systems, for example, companies will only know about 10 of them. So 90% of that unknown, because the regulation applies on what you use, not what you're aware of. So the early example where I asked you who's aware of Microsoft training models on your data. Technically, if you're using Word, you're using an AI system, but you're not aware of it. So 90% of them are unknown and applies to all algorithms, models, LLMs, and critically, any SaaS applications connected to the cloud. So any SaaS product that's connected or supported by Azure, AWS, IBM Cloud, Alibaba, whatever, is within scope. Okay, yeah, so we mentioned the Microsoft example here. There is a link here, so I can send the slides to you later if anyone's interested. This is a web link. And these are three examples of algorithms covered by legal definition. Copilot by virtue of the fact that it's an AI system. If you use read aloud, so it actually listens to your Word documents, and then if you use Excel, analyzes your data. So I agree it's pretty pertinent that these are examples of AI systems by legal definition. Just to give you guys a snapshot on the state of AI regulation, we have the EU AI Act front and center, risk-based approach to regulation. So you've got high-risk systems conformities, risk tiers. The UK, obviously we're in the UK now, it's sector-led principles focused. This may change, and there is a consultation coming out in Q4 this year. It's not formal, it's not statutory, it's more, okay, it's sort of like an all boys club type thing at the moment. We don't know how long that will last. Then you have the NIST framework in the US. So this is more of a risk management framework convened over the past 2 years that sets out how to manage the risk from AI systems. It is voluntary, but it is trusted by financial institutions. And I personally have referred to this a lot. And we've actually included it in some training we're giving to financial institutions. And the OECD AI principles. Can't forget these. These actually influenced a lot of the EU AI Act. And there's around 10 of those. And 38 plus countries help put these together. I'll probably skip that one because I'm cautious of time, Yaro. One key thing to mention here is when people talk about ethics, it is subjective, and it's beautiful because everyone has a different perspective of this. But from an EU standpoint, the high-level expert group of experts came together and put together these 7 principles which were enshrined or codified in the EU AI Act. And each one of these you could probably have a dissertation on, and you could have various difficult technical papers and metrics, and yes, there are. These are so important because it actually shows that compliance with the EU AI Act implies that the system is ethical and adheres to all of these. Obviously, what we say to companies is get these principles, map them out, map each of them and showcase how you're complying with them. Because each one there's no specific weighting, so it doesn't mean that accountability is more important than diversity, or societal and environmental well-being is more important than transparency. They each have equal weighting. And the key takeaways from this is that global AI regulation is accelerating. So it's not just the technology, the regulation is too. It does set the tone for risk-based governance. So we have reached a stage in the maturity of the industry where the risk that an AI system poses needs to be accounted. So when senior decision makers are deciding whether to design, deploy, maintain, or even decommission a system, the risk that they take is key. So in the example I gave you earlier, once you've got that risk level, the inventory and the risk level of all your AI systems, a strategic decision will then be taken based on that. It's cross-disciplinary practice, so everyone from input from civil society to universities to industry to senior ethics and legal advisors. It's not a case where everything's just shoehorned under one person. It's cross-disciplinary, so everyone has a role to play, everyone's voice matters, and everyone should play a part in this, and that is important. From a business standpoint, sure, ethical AI is good, but not just paying lip service to it, actually being showcasing ethical practice. And early action pays off. So what a good friend of mine from the US has done a lot of work around this, and she is now achieving some amazing things. And another friend of mine who I just spoke to before I came here he's just been invited to a closed working group at a UN level to help with ISO 42000 work he's been doing. So early action does pay off, and hopefully for you guys being here, that will help. I don't know if we have any time for questions. No, I'm sorry, but thank you so much, guys. I appreciate your time.